it is available. If the public information officer does not know where the information is available, then only he can give an endorsement and he can say, he can take a decision that the information available is not available with them and he is not aware with whom this is available. This is one of the very important section here. बहुत से when we analyze the law, the cases, appeals coming before the information commissions, about 20% of the cases, when at the time of hearing, the public information officers give a reply that the information is not available with them, and they have not transferred it also to the concerned authorities here. The information commissions are taking a very lenient view on these grounds and simply closing the cases by directing the public information officer to transfer the application to the concerned authorities. This is what is generally happening in almost all information commissions. Yeah. None of the commissions, most of the commissions are not imposing penalty for delay in transferring the application to the public information officer. This is also one of the important reason why public information officers are not adhering to this section very properly here. There is one important, recently, one RTI activist, one Mr. Kishore Rao, was a very senior activist. He made an application to the Tahsildar of Bangalore North, seeking certain information regarding the land records are concerned here. He made an application on 16/12/2016 before the Tahsildar, the public information officer. The public information officer did not transfer it to the, it was not available with him, but he kept quiet without transferring it and without giving any information to the appellant. The appellant filed a first appeal. Even in the first appeal, he did not get any answer. Even the first appeal was also not heard properly. He approached the Information Commission. The Information Commission took up the case and issued a notice to the Tahsildar. But when this case came up before the Information Commission, he made a reply that he has transferred the application on 8/5/2018 to the Assistant Director of Land Records with whom the information is available. That means only after filing a second appeal, he gave a reply and transferred the application after a period of 17 months. Mr. Kishore was a very senior RT activist here. He argued before the Karnataka Information Commissioner that it's a fit case for levying a penalty because he has violated the provision of Section 6(3) of the Act by not transferring the application within 5 days from the date of receipt of the application. But Information Commissions takes a very lenient view on these issues are concerned here. Almost majority of the Information Commissions are very sympathetic towards the public information officers. Even here case, he vehemently argued the case here. The result is he was blacklisted by that particular Information Commissioner, and when there was a lot of pressure on him, simply imposed a penalty of 5,000 rupees and closed the case here with a direction to provide the information. The commission. This was taken up with the Chief Information Commissioner. The activists, we took up this case with the Information Commissioner. We said that where is the provision for levying only a 5,000 rupees penalty when there is a provision for, why don't invoke the provision for imposing the maximum penalty of 25,000 so that it would give a it will lead a good example for other public information officers who violate this provision itself. So the commission, even then the commissioners, they were taking a very lenient view on such issues. So finally, a writ petition was filed before the Karnataka High Court by the Kishore Rao, the appellant here. This was heard by the High Court of Karnataka, and they passed an order on 18th March 2021. That is 2 months back here. Very landmark judgment. I have sent a copy to the Dwivedi sub को मैंने forward किया है. I request him to forward it all to the participants here. So it's a very landmark judgment by the Karnataka High Court regarding the transfer of application 6A of the Act here. That I'm not going to the details here. मैं द्विवेदी साहब को रिक्वेस्ट कर दूंगा इसे सर्कुलेट करने afterwards here, that I will tell the important provisions is here. The High Court made a very significant note on the particular case here, and he made a very excellent remark. The judge has, Mr. Justice Suraj Govindraj made a very, he passed a very excellent order. He said the purpose and intent of the Act is not only to provide the information sought for, but also to provide it within a time-bound manner. Otherwise, it would be defeated in the event of there being any delay. He said, if the information is not provided within the stipulated period, it will defeat the whole purpose of getting the information. Then in para 10, he said, undue delay, as in the present case, where the application which had to be transferred within a period of 5 days has been transferred after 17 months is inexcusable here. He said it cannot be accepted. Commissions cannot accept such reasons here. That here in this case, the PI was so adamant, even he did not appear before the commission. He sent in a lawyer official who represented him here. In the next para, he says, there is no explanation offered by the respondent, either before the appellate authority or before the court or the said delay. Even the public information officer did not respond to the notice of the Karnataka High Court here. You see, this is how they are taking it granted. Even they don't care even for the High Court orders. That is the reason why RTI has become very, very weak here. But he says, in the absence of such explanation being tendered, I am of the considered opinion that the delay is admitted. That means the delay is admitted and the same cannot be condoned. The commission has imposed a penalty of 5,000. The appellant argued that whenever there is a delay, the commission has no discretion to impose a penalty of 5,000, lower penalty less than 25,000 rupees. Even some of the cases we have seen, the information commissions are imposing penalty 2,000 rupees, 3,000 rupees, depending on the commissioners. But in this case, clearly said, when there is a delay, the commissioners have no discretion except to levy the penalty at the rate of rupees 250 per day. He says in the order it is very clear. As such, in terms of section 20 of the RTI Act, a penalty of rupees 250 per day is required to be imposed on respondent for such a delay. The said amount, High Court said, the said amount calculated for the said delay would be amount to rupees 1,29,000. Because there is a delay of 17 months for transferring section 6 under section 6(3) of the Act. The court says the penalty allowable is 1,29,000. However, the RTI Act imposes an upper limit of 25,000. Therefore, the High Court directs the respondent, the Tahsildar of Bellur North, to pay a penalty of 25,000 rupees. They said the order clearly says that a penalty of rupees 5,000 imposed by the Karnataka Information Commission is not acceptable here. This is one of the good order. Recently, 2 months back, it has come from this. It was released by the High Court of Karnataka. So I think if we join together and see that this order is properly implemented and brought to the notice of the information commissioners during the hearing of the cases, wherever there is a abnormal delay in transferring the application to the under section 6(3) Act, I think this order will be a deterrent for the public information officers in future here. This is one of the good orders. And we have got another peculiar problem under section 6(3) of the Act here in Karnataka. Suppose I make an application to the Director General of Police seeking certain information regarding a particular general information regarding from the police department. What they are doing is here, the Director General of Police, he is transferring it to the all Superintendent of Police and commissioners of police in the state. There are about 30 districts and about 8 commissionerates. He will transfer it. Then later on, what they do, these Superintendent of Police and commissioners, they transfer it to the all police stations. So there are about 800 police stations in Karnataka state here. So this single application will be transferred to all the 800 police stations here, and this appellant start receiving informations from one by one police station. Some will reply, some will not reply here. So your purpose of making the application is totally different, because you are not getting the information on point. Even if the information is available in the office of the Director General of Police, they are not giving it. Simply they are in the habit of transferring it to all the police stations. This is the state here. So when such cases were taken before the Information Commission by the appellants, instead of directing the Director General of Police for wrong interpretation of the 6.3, they are passing remarks on the application for making such applications here. This is how this section 6.3 is being misused by the public authorities. And now, recently, about 2 years back, the Karnataka on the recommendation of the Karnataka Information Commission, a circular was issued by the DPR Janaspandana, which is the nodal agency for implementation of the RTI. Now they have issued a circular. If I make an application to any public authority, and if the information is available with many public information officers, then they need not transfer it to the under section 6.3 of the Act. Instead of it, they should issue a circular. They should issue an endorsement stating that the information sought by the appellant is available with the various public information officers, and the applicant has to make a separate application to all the authorities. This is how the RTI Act has been further weakened by issue of the circular here. So this is how the transfer is not being done properly. This this section is being misused by most of the public information officers to and thereby we are not getting the information correctly here. So this I think we will debate on this. I think I request the participants to debate on this writ petition number 24432 of 2009, that is Kishore Rao versus Tahsildar Bangalore North, wherein the delay for delaying transfer, a maximum penalty of 25,000 rupees is imposed. If we see that this order is properly implemented by the information commissions across the country here, I feel that here we can bring some change and some improvement in the implementation of the RTI's concept here. धन्यवाद. इसी के बारे में कोई प्रश्न हो तो आप पूछ सकते हैं.
जी Veeresh, Bellur ji, thank you very much for bringing this very important order by the Karnataka.
आप हिंदी में बोल सकते हैं, मैं समझ सकता हूँ. द्विवेदी जी.
No, yeah, I understand. जी. तो सर धन्यवाद आपका इस ऑर्डर के लिए जो आपने अभी यहाँ पे शेयर किया है. हम उसी की चर्चा कर रहे थे. जैसा कि आपने कहा, हमने इसको यहाँ जूम के प्लेटफॉर्म में भी हमने शेयर कर लिया PDF फाइल में, और साथ में जो लोग व्हाट्सएप ग्रुप में जुड़े हुए हैं, आई हैव ऑलरेडी सर्कुलेटेड इट देयर. तो ये 18 मार्च का ऑर्डर है, जिस प्रकार से बेल्लूर सर ने बताया है. तो आप लोग इसको देख लीजिएगा. रिट पिटीशन नंबर है 24,332 और एम किशोर राव का ये मामला है वर्सेस इंफॉर्मेशन कमीशन और जो भी उसमें उनकी पार्टी PIO वगैरह. तो इस ऑर्डर में जिस प्रकार से उन्होंने कहा है कि मैक्सिमम 25,000 रुपए फाइन इसमें लगाया गया है, और इसमें हाई कोर्ट का ये ऑर्डर सही तरीके से इम्प्लीमेंट किया जाता है. तो जो भी इस तरह से आप देख रहे हैं कि जो लोग जवाब नहीं देते हैं, कोई रिप्लाई भी नहीं देते हैं और सही तरीके से 6.3 का उपयोग नहीं कर रहे हैं, वहां पर और वो फाइन से भी बच जाते हैं. क्योंकि कई बार जिस प्रकार से बेल्लूर सर ने बताया कि कई बार ऐसा होता है कि आप देखते हैं कि इंफॉर्मेशन कमीशन भी ज्यादातर ऐसे PIO का ही पक्ष लेता है और मिनिमम इस तरह से फाइन इम्पोज करता है या बिल्कुल नहीं इम्पोज करता कई सारे केसेस में. तो ये दुर्भाग्यपूर्ण है, और ये ऑर्डर जिस तरह से है ये काफी महत्वपूर्ण रहेगा इस दिशा में. यदि लोग इसको फॉलो अप करें, और सभी लोग हमारे जो RTI से जुड़े हुए कार्यकर्ता हैं, साथी हैं, इस ऑर्डर को आप लोग प्रिंटेड फॉर्म में और इसका साइटेशन आप नोट कर लीजिए. और जब भी कभी ऐसी स्थिति आए आयोग के समक्ष या PIO के समक्ष, तो आप लोग इसको साइड करिए और उनको बोलिए कि वो मैक्सिमम 25,000 का फाइन उनके ऊपर इम्पोज करे, इसी का हवाला देकर। और यहाँ पे अब हम कार्यक्रम में वापस आते हैं और हमारे बीच में माननीय श्री शैलेश गांधी जी, पूर्व केंद्रीय सूचना आयुक्त, सर स्वागत है आपका, जुड़ चुके हैं। मध्य प्रदेश राज्य सूचना आयुक्त वर्तमान माननीय श्री राहुल सिंह सर जुड़ चुके हैं, सर स्वागत है आपका। और आत्मदीप सर हमारे बीच में पहले से जुड़े हुए हैं। तो हम जैसा कि इनवाइट कर रहे थे, उस समय आत्मदीप सर को थोड़ा सा टेक्निकल प्रॉब्लम आ गई थी, तब वो सुन नहीं पा रहे थे। तो आत्मदीप सर इस विषय पर प्रकाश डालिए कि किस तरह से जो लोग सूचना अधिकारी हैं किस तरह से 6(3) का मिसयूज कर रहे हैं, और जो भी हमें जानकारी ये देते हैं। तो कई बार ऐसे, या कि हमें हमारे साथ ही कई बार ऐसा हुआ है कि हमारा RTI आवेदन ही वापस कर दिया कि यह इस कार्यालय में नहीं लगेगा। और जब कभी सपोज करिए कि उन्होंने RTI आवेदन वापस नहीं किया, तो एक पत्र उन्होंने दे दिया कि ये जानकारी हमारे पास नहीं है, और उन्होंने उसको 6(3) के तहत अंतरित नहीं किया। कई बार तो हम 6(3) के तहत मांग करते हैं कि यदि जानकारी आपके पास ना हो तो आप 6(3) के तहत उस कंपिटेंट कार्यालय में आप उसको अंतरित करिए। तो उस स्थिति में भी वो नहीं करते। यदि हम यह भूल गए हैं कि 6(3) का लिखना, तो मतलब ये उनका दायित्व होता है, कर्तव्य होता है कि वो 6(3) का उपयोग करें, यदि हमने नहीं भी लिखा है, डिमांड नहीं किया है तो सर इसमें थोड़ा सा प्रकाश डालें आप।
देखिए, धारा 6(3) में यह स्पष्ट प्रावधान है कि यदि किसी RTI में ऐसी सूचना मांगी जाती है जो लोक सूचना अधिकारी के कार्यालय में उपलब्ध नहीं है, तो वह ऐसी